Let me tell you what happened in this country when the government decided your gun was too dangerous for you to keep. They didn't kick down your door, they didn't send police. They sent paperwork, a letter, a notice, and if you didn't comply, then they sent police. That's the part nobody talks about. These laws don't look like confiscation on the day they pass. They look like safety measures. They sound reasonable. They get sold to the public as common sense. And by the time gun owners realize what actually happened, the compliance deadline has already passed. I'm going to walk you through exactly what's going on right now, what these laws actually say versus what politicians are claiming they say, and most importantly, how to what this means for you as a gun owner today. Stay with me, because there's a piece of this that almost everyone gets wrong, and it could cost you your rights permanently. I've spent years analyzing gun law, Second Amendment litigation, and the legal exposure that everyday gun owners face when the law changes around them. I'm not here to panic you. I'm not here to politicize this for clicks. I'm here because when a law passes that affects your rights, your property, and potentially your freedom, you deserve a straight read on what it actually means. So let's get into it. Look, gun owners have been fighting bad legislation for decades. That's not new. What's new is the mechanism. For most of American history, when lawmakers wanted to restrict firearms, they went through Congress, they went through state legislatures, they faced votes, they faced public scrutiny. That process was slow. It was visible. Gun owners could organize against it. What's been happening more recently is different. We're seeing a shift toward regulatory action, right? Executive orders, agency rulemaking, and administrative reclassification, right, that bypasses the traditional legislative process. And when policy gets made through regulation instead of legislation, it can move fast, it can be buried in technical language, and most people don't hear about it until it's already in effect. That's exactly what makes what we're seeing now so significant, because we're not just talking about a bill that failed or passed, we're talking about frameworks that are being built right now, right at the federal and state level, that could redefine what counts as a legal firearm, who counts as a qualified owner, and what safe storage actually requires of you legally. And here's the first thing most people get wrong. When you hear the word safety attached to gun legislation, most people picture trigger locks and storage boxes. That's what the marketing says. That's the headline version. Here's what the legislation often actually contains. Many of these bills don't just recommend safe storage, they mandate it. They specify how a firearm must be stored, sometimes in a way that makes it functionally inaccessible for self-defense. And some of them include inspection provisions, meaning there is a mechanism by which compliance could be verified. Read that again, inspection provisions. That is a legal mechanism to enter your home and verify that your firearm is stored according to government specification. Now, some of these provisions get challenged in court immediately. Some get stripped out before final passage, but some don't. And the ones that don't become law. Real law. Law with real consequences. The broader pattern here is what matters. When a bill is called a safe storage law, the public hears, lock up your gun so kids can't find it. What the bill sometimes actually creates is a legal framework around how you can possess, store, and access your own legally purchased firearm inside your own home. That's a fundamentally different thing. Let me address the word directly, confiscation. Gun owners use that word and the media immediately calls them hysterical. But here's the legal and practical reality. If the government reclassifies a class of firearms or accessories and gives owners a compliance deadline to surrender, modify, or destroy the item, and non-compliance is a criminal offence, that is functionally a forced divestiture of private property under threat of prosecution. You can call that confiscation or you can call it something else, but the outcome for the gun owner is the same. You either give it up or you become a criminal. This has happened, not in theory, not in some hypothetical. It happened with bump stocks at the federal level. The ATF reclassified them as machine guns. Owners were given a deadline. Possession after that deadline became a felony. There was no compensation, there was no grandfather clause for existing owners. The Supreme Court ultimately ruled on this, Calibra, and the ruling in Garland v. Cargill was significant. But the mechanism that was used to implement that policy is still intact. The regulatory reclassification playbook exists, and it can be used again. That's the part that should concern every gun owner, regardless of what you think about any specific type of firearm or accessory. Because today it was bump stocks. Tomorrow, the same framework gets applied to something else. And the question isn't whether you own a bump stock. The question is whether you're comfortable with a federal agency having the authority to reclassify your legally owned property into contraband overnight. Here's where I'm going to say something that might surprise you. The Second Amendment protects you less than you think it does in practical day-to-day legal reality. I say that not to demoralize you. I say that because understanding it clearly is what actually protects you. The Second Amendment, as interpreted since Heller, protects an individual right to keep and bear arms, particularly handguns, in the home for self-defense. That's a huge and important ruling. But it also established that the right is not unlimited. And every piece of legislation that gets challenged under the Second Amendment goes through a legal analysis that asks, does this law fall within a tradition of firearm regulation that was historically acceptable in this country? That standard, the historical tradition test that came out of Bruin, has been a significant win for gun owners in many cases. It's struck down red flag laws, certain magazine restrictions, and more. Courts are working through these questions right now. But here's the catch. Litigation takes years. While a case winds through district court, circuit court, and potentially to the Supreme Court, the law is in effect. You are expected to comply with it. And if you don't comply while you're waiting for the courts to sort it out, you can be prosecuted. So even if a law is ultimately ruled unconstitutional, and some of these laws will be, you cannot simply decide not to follow it in the meantime and expect to be protected. That's not how this works. And gun owners who don't understand that distinction have ended up with felony charges on record for what they thought was principled resistance. That's the reality. The courts may be on your side long term, but the law on the books today is the law you have to live under right now. Let me give you the structural pattern that these laws follow, because once you see it, you'll recognize it everywhere. Step 1. A high-profile incident occurs. The public is grieving, angry, and scared. The political window opens. Step 2. Legislation gets drafted fast, often referencing the incident and given a title that makes opposition politically difficult. Safe storage, red flag. Common sense reform. Step 3. The bill passes, often with provisions that go well beyond what the headline suggested. Details get buried in subsections. Implementation authority gets delegated to an agency. Step 4. Agency rulemaking happens. This is where the real teeth get added. An agency can take a vague statutory authorization and write regulations that are extremely specific and extremely restrictive. And those regulations go through a different process than legislation, one with far less visibility. Step 5. Compliance deadlines. Short ones sometimes. Gun owners who don't follow the news closely enough miss them. Step 6, enforcement, which is the step where the safety law stops looking like a safety law. That's the pattern. It has repeated itself multiple times in multiple states. And it is repeating right now. Here's where we are. We've talked about how safety framing conceals structural changes to firearm possession rights. We've talked about how regulatory reclassification can effectively confiscate property without calling it confiscation. We've talked about the historical tradition test under Bruin and why it helps, but why you cannot simply ignore current law while litigation plays out. And we've walked through the 5-step legislative pattern to watch for. Now let me tell you what to actually do. First, know what laws are active in your state. Not what you heard someone say at the range, not what a Facebook post summarized, the actual current statute. If you're in a state with significant gun legislation in the last 2 years, California, Washington, Illinois, New York, Colorado, New Mexico, you need to know specifically what changed and what it requires of you. A 1-hour conversation with a firearms attorney in your state is worth more than 100 YouTube videos, including this one. Second, Understand what you own. This sounds basic, but it matters. If you have a firearm or accessory that has been the subject of regulatory attention, short-barreled rifles, suppressors, pistol braces, certain magazine configurations, you need to know the current legal status of that item. Not the status from 3 years ago, today. Third, if you own NFA items, you already understand the registration system. If you've been thinking about items that require registration and you've been putting it off, you need to understand that reclassification risk is real. Items that are legal today may not remain legal under the same terms tomorrow. Fourth, take safe storage seriously. Not because the government tells you to, but because it's the right thing to do. And because it removes ammunition from the people who want to use incidents involving unsecured firearms to pass more restrictive law. Every time a legally owned firearm is accessed by someone who shouldn't have it, it becomes a data point in the argument for the next wave of legislation. Fifth, stay engaged in the legal process. Donate to Second Amendment litigation organizations. Know who your state legislators are and what they voted on. Show up when there are public comment periods on proposed regulations. Regulations can be challenged. They can be killed before final adoption, but only if people who care actually engage. Here's the bottom line. What's being called safety legislation in this current cycle is real. It's moving, and parts of it go significantly further than the title suggests. The confiscation accusation isn't hysterical. It's a reasonable description of what forced divestiture under threat of criminal prosecution actually is, regardless of what you call it officially. The good news? The legal landscape has shifted in favor of Second Amendment rights in a meaningful way over the last decade. The courts are doing real work. Cases are being won. The caution, the legal process is slow and it does not protect you from prosecution while it's ongoing. You have to know the law you're living under right now. The action, talk to a firearms attorney in your state, know what you own, know what it takes to be in compliance, and stay engaged in the political and legal process, because the people pushing these bills are not stopping. The founders didn't put the Second Amendment in the Bill of Rights because they trusted government to be permanently reasonable. They put it there because they knew it wouldn't be. The question isn't whether your rights are worth protecting. The question is whether you know enough to protect them when it matters. If this helped you understand what's actually at stake right now, subscribe, hit the bell. Because laws change fast, the news cycle doesn't always cover what matters for gun owners, and this channel will. Stay informed, stay legal, stay ready.